The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, Attorney Stuart M. Address.
Good morning, Treasure Coast. It is Friday again, 10:05, and it's Ask a Lawyer. I'm Stuart Address, and for the next hour, I am here to answer your questions, if you have some today, on almost any topic. If it's not a topic that I am familiar with, not in my area of practice, I will tell you and try to let you know where you might be able to go to get some guidance. But generally, as those of you who have listened before know, I do general civil litigation, which means a little smattering of almost everything that's not criminal and not probate, not wills, things like that. I have an emphasis in employment and discrimination and civil rights, but you would be surprised at the types of things, varied things that come into my office over the years. So give us a call at 340-1590. We're going to continue our discussion today of landlord-tenant law and see if we can give those of you who either rent or are landlords a little bit of information that you might not otherwise have. And if that sparks any questions, give us a call. And before we start, I'd like to say, happy birthday, Mom! Happy 82nd birthday! I will see you on Sunday. And with that little plug, let's get right into it. All right, last week we sort of ended the show talking about the landlord's responsibilities in a residential lease, where there's either a lease or there isn't a lease. So let's go now, let's flip it. What are the tenant's responsibilities or the tenant's obligations? Most of them are really self-explanatory, self-obvious, things that the average person is going to do anyway and should do. It's not rocket science. You know, usually there's all these little tricks in the law, and there are specifics in the Florida statutes. But let's be realistic. Don't destroy the house. Don't damage it, intentionally or accidentally. Keep it clean. Do the things that you would normally do if you're living in a property that you own. That's common sense.
Now, wait a minute. I would have to clarify that just a little bit.
Go ahead.
Because people, when you own, you can live however you like. But if it's not yours, you should live
better
the way that you're expected to. Because it's not yours. You should. I just believe you should take better care of someone else's belongings than.
I understand that perspective. I think when you own, you certainly are looking towards the equity in whatever it is you own, and you want to preserve it, so there's a built-in motivation to keep it in good condition.
Yeah.
But I do understand your perspective as well.
Yeah, I mean, you can paint the bedroom black if you like, if it's yours.
Unless the lease says no, you can paint the bedroom
I'm
black
saying
anyway. You may have to paint it back.
Yeah. Oh.
I mean, you want to do psychedelic, unless the landlord's put a restriction on you, I guess you can. Now, some of the little things that, you might not know. We talked last week about, specific responsibilities of a landlord. One of them not being air conditioning in Florida. Heat, yes.
Yeah, that's amazing.
But not air conditioning. So, yes, there are things that would be common sense and it's counterintuitive. And that's because it's not just the Florida legislature, it's every legislature. Sometimes is a little foolish. Sometimes it contradicts with other statutes and they haven't reconciled all of them properly. And sometimes you just overlook things. Hard to overlook air conditioning, I think, in Florida. But then again, they're up in North Florida, the Florida capital, Tallahassee, and, things, even I think occasionally get some snowflakes. So maybe they were more worried about heat. I don't know.
Yeah.
I don't know where the southern, legislatures were, when they did that. But that's a story for another day, I guess. So in terms of, electrical, plumbing, sanitary, heating, ventilating, air conditioning, elevators, how many of you have elevators? Trust me, I've actually seen a few. Just operate them and keep them the way they essentially were. Now, normal wear and tear is to be expected. And we do get into this issue when tenants move out and landlords seek to keep security deposits or parts of them so that they can do cleaning, so that they can do painting. That is not necessarily kosher. Ordinary wear and tear is something that you don't lose in your security deposit. If the rugs are 10 years old and now they're 12 years old and the landlord wants to replace them, unless you put holes in these rugs, it's not your fault.
Mm-hmm. Or paint.
Or paint, right.
You've done something that can't be.
If the landlord, and good landlords, wants to repaint every time a tenant moves out.
That's a good landlord.
That's a good landlord. I think that's wonderful.
Yeah.
But if you have not done anything to the existing paint that really makes it so that it needs to be done, it doesn't come out of your pocketbook. Mm-hmm. It comes out of the landlord's pocketbook. Sure. So we often get calls about, well, the landlord wants to keep my security for this or for that, for the other thing. And what we look at is reasonable wear and tear and damage. And if it's beyond reasonable wear and tear, then the landlord may have some claim. Now the question becomes, to what extent? All right. If the carpet is 10 years old and the replacement cost for that room is $2,000, they don't get to deduct your whole $2,000 security deposit. Mm-hmm. The value of that carpet, as any insurance company would likely tell you, if it was destroyed in a fire or a hurricane, maybe $100. Well, that's what the landlord may be able to get out of you. So we often get into these disputes. The disputes that deal with small amounts of money, which usually a security deposit does, we try to talk rationally to the landlord or to the property manager and just get it resolved with a phone call or two or a letter. If that doesn't work, then as we mentioned last show, the landlord has to take certain appropriate steps under the statute to make a claim to your security deposit. If the landlord doesn't do that, there is no claim to your security deposit. If the landlord complies with the statute, gives the proper notice, explains the reasons, the amounts, and you disagree, you have 15 days to contest it in writing. If you don't, you can't fight back. So that's where, when it comes to any law at all, there are things that the average person is not going to know. That's why you ask a lawyer, okay? But a lot of this landlord-tenant stuff really is common sense, and we start there, and then we go to the statute, and when we get calls, we try to, fill in the blanks of things that people might not normally know because they're not lawyers. I mean, look, I got a handyman, that has been working at my house and is coming back actually today, putting up a wonderful wall unit, and it's going to put a TV in there. I didn't know I needed a high-definition HDMI cable, and that once the thing's up and it's all hidden behind the walls, it becomes harder to do, so I need it now. Well, okay, I'm glad he told me because otherwise I wouldn't have known it, and then later on, a week from now when I wanted it, getting it behind the wall unit that's installed would have been a big, as they say, a big Megillah, and I don't know that. I'm not a handyman.
Right.
I don't know anything about plumbing. I don't know anything about electricity. I don't know anything about anything that I should know owning a home. So I have to rely upon other people. Hopefully I know enough about law.
So did he say if you want the TV to work, you gotta get a wire in here?
He said he would get me a high-speed HDMI cable when he comes over. So I said thank you, and we'll put it on my bill. So let's say you're moving out, and you are peeved at your landlord. Don't take it out on the property. I'm telling you, folks, it's not worth it, because not only will there be a claim against your security deposit, there'll be a claim against you for anything that is exceeding the security deposit. And you may say, well, I don't really care. Let them come after me. Well, when they do and they get a judgment, and that judgment includes court costs and attorney fees, and it's 5 times the amount of what was really at issue, you may care when they start trying to garnish your wages. So, I've been, when I've rented, I've a couple times been irritated with my landlord, and just don't do it. Leave the place, as they say, broom clean, and take pictures. Take pictures of everything. Take pictures of the corners. Take pictures of the walls. If there are little holes in the walls from your pictures, take pictures of the holes so that it can't be claimed that these were monster holes that required, a carpenter to come in. Really, take pictures. And the same goes for when you move in. Take pictures. In fact, I've seen clients these days, now that everything is in the palm of our hand, take video.
Mm-hmm.
Walk around the house, even when a hurricane is coming, a homeowner. Walk around the house and video all your significant, belongings so that, God forbid, it's a lot easier to make your claims.
Well, I think even after you've shuttered, walk around the house and show your house shuttered.
That is a good idea, too.
Your insurance company may come back later and go, well, you didn't secure your house.
Well, I think...
And you could go, yes,
in a major hurricane, one of those shutters will probably be half on, half off.
But
it'll be easier to prove.
At least you go, we did everything we could.
That's right.
Mm-hmm.
And that also, it is common sense. But I'll be honest, we get tons of calls, and what I guess as a lawyer I might think is common sense, other people don't think about. And, what a plumber or an electrician might think is common sense might never, ever cross my mind. So, I try not to be judgmental. But whatever it is, you've got to do your best at, protecting yourself. And when you move into a place that you're renting, document everything. And when you're leaving, document it on that last day after you swept everything, as they say, broom clean, and everything's been moved out. That's the time to take your photos. All right? So, now what happens if you need to terminate the rental agreement, not because, you got a better job in Dallas and you need to move, and that's a whole other story. It's not for this show. Unless you call and ask me, then it'll be for this show. What happens if the landlord is not providing you heat? What do? Okay, I understand. First thing you're going to do is either call the landlord or the property manager and say, I don't have heat. And hopefully they are very responsive, especially if it's February and we're going through one of our 2-week cold spells.
And it's a mechanical thing.
Okay.
It can go bad.
But if you find out that nobody is responding, within 24 hours, the next time you call, email as well, or fax, or send a letter, snail mail if you have to, certified. Do something that proves your complaint. Even if you don't even want to call it a complaint. We have a problem.
It's a request.
Yeah. We have a problem here.
Yeah.
We called once before. We really need it taken care of right away. It's 45 degrees, it's frost, and, my little child is really cold. Put it in writing, okay? If you're clearly not getting a response, then you can't just withhold rent. I have tenants who have chosen to do that.
I think it's a brilliant idea.
Well, as a landlord, you do, because then you can evict them.
No. I think that if you're a good tenant and you're paying your rent on time and you have a reasonable request because something's not fixed and you just don't ever get it fixed, you fix it and you hand them your rent with the bill.
Well, there are some prerequisites to do that and be protected. But before we continue with that, We have Nikki on line one. How can I help you, Nikki?
Sir, approximately 5 years ago, my wife and I started making investments with a fellow by the name of Gilchrist out of Fort Pierce. Now, we went to his seminar, and after the seminar, we were dealing with the son, and we were investing in securities, and then approximately a year and a half ago, the son starts to state to us that this Woodbridge Corporation would be a better investment, higher earnings. Okay, we went into that, and we're listening to him, and however, very stupidly, I didn't ask what his entire credentials were.
Okay.
Now, come to find out, the father has been investigated, and it was made known that his company was also being investigated by
the SEC?
state. I beg your pardon?
I was just going to say, was it the SEC?
Yeah.
Okay.
And in turn, this whole Woodbridge situation has gone into bankruptcy. That's including the states of California, Utah, Kansas, North Carolina, Delaware, and New York. And right now, the court proceedings are out of New York and Delaware.
Right.
Okay. We have lost at this point $326,000.
That's a lot of money.
Okay. Now, I don't know whether the father has been prosecuted, to what extent, if any, and I don't know about the son. The son is in Sebastian. What would be my avenue to
recover?
State this loss for income tax?
For income tax.
Well, that was one concern of mine.
Okay. For income tax, I have to be honest with you.
Yeah.
And I don't know.
Okay.
I don't have the foggiest, so I wouldn't even want to try to give you an educated answer because I don't have one.
All right.
But I don't know if have involved yourself, in making claims, in the criminal matter or in the investigative matter, or if
Yes.
there's any civil matters.
Yes, we did
Okay.
with the state.
Okay. So
And we met with them
okay.
2 months ago and gave them all the information, and they were going to begin looking into the whole deal.
All right. So you've met with the state, and if I understand correctly, they're also being investigated by the federal authorities.
Correct.
And there are some pending actions, or is it still an investigation?
I don't know about the investigation, but there are actions where the courts have gone into investigating and
have you made sure that in those actions you have filed claims and done whatever you need to do to show the amount of loss that you suffered?
yeah.
Okay. Well, unfortunately, I've heard of these situations before, and the biggest example, Bernie Madoff. Mm-hmm. Okay.
Okay.
My beloved New York Mets, for years and even now don't sign a lot of big free agents because Madoff made off with hundreds and hundreds of millions of dollars of the Mets owners' money. And matter of fact, even one of the Mets owners had to kick back some of the profits they made. It's called a clawback suit, even though they didn't do anything wrong, but they were trading on information that Madoff had provided.
Okay.
In your situation, if you've made the claims with the state and federal authorities,
Yes.
I think you have probably done as much as you're going to be able to do in terms of an effort to recover money.
Okay.
My assumption, and you correct me if I'm wrong, my assumption is that the actions that have been filed and the investigations that are underway are against both the son whom you dealt with, who recommended the Woodbridge investment,
Yes.
and the company, so that there's an opportunity to recover from both. The company may have no assets, it may go bankrupt. The individual, may go bankrupt as well, but at least there's two avenues, if there are any assets there, to try to get some recovery. Obviously, I don't know the extent of the overall loss, and whether it was an intentional, deception of investors, or whether it was an investment gone bad.
Yeah.
One of the things I was going to ask you, but since you've dealt with the regulators and made your claims, I think I know the answer, is whether or not when you made your investments, whether you made them under a prospectus, which they would have been obligated to provide you before they accepted any money from you for an investment in a security.
Okay.
Okay? So I know enough about securities litigation to be dangerous. And what that means is, as a generalist in civil litigation, I know that there are certain things you need to do, but if I was going into court, I would probably say you need a securities lawyer, not me.
Okay.
So I know enough to be dangerous.
Right.
It sounds as if, since this happened a couple of years ago, that you've done pretty much the right things, dealt with the state and the federal authorities, and unfortunately may only recover a small percentage of your losses,
Right.
if anything.
Mhm.
And I don't think there's really much more that you can do, but to protect yourself, and I don't know if you've done this yet, I would strongly recommend that you call a civil securities lawyer to find out whether there might be anything that you haven't yet done that you can do to put some pressure somewhere. Because
Okay.
a lot of litigation is about leverage. If you can find a point of leverage, you may get something that somebody else doesn't.
All right.
And I think that's probably the best I can do to answer those questions.
All right, sir.
I hope it helped a little bit.
Well, at least it gives me another avenue to investigate.
All right, I wish you luck, and I know, a lot of people have these unfortunate experiences, and, when it's caused by deception, it makes it a lot worse. I wish you the best.
All right, sir. Thank you very
Thank
much
you.
for your time.
Okay, you're very welcome. So, that is a situation that I've dealt with. I've had calls. One of the first things I look at is, if there are securities that needed to be registered, was a prospectus provided, were proper disclosures made.
Do you want to take a quick break for the news?
Let's take a
We do have
we have a
let's take
caller
the-
on the line,
all
so
right.
let's take the caller. The caller is more important than the news, and I think we have Bill on line 2. How can I help you, Bill?
Hello. I have a piece of property on the water. It's a vacant lot, and I had a fence around it, and I had a little place I could pull my car in, and I had palm trees and plants. And I came back down from New York, and it was all gone. The fence was gone. The postage signs were gone. The neighbors leveled it so they could have a view of the water.
Really?
Yeah.
I've
Yeah.
heard those stories before, too.
Yeah, so I didn't know what to do. I went to the town, and they told me I could put up a fence, so I put up a fence. But, every time I go there, I get harassed by the neighbors, like I'm not supposed to be there, because they like seeing the level beach instead
Right.
of me, So I'm wondering if I have an issue there.
You do. Look, from the neighbor's perspective, I understand they want an unobstructed view of the water. It's pretty, and,
I put a house there.
Right, everybody wants it. Exactly. You put a house there, it's
Put
going
a
to
house
be even
there.
worse.
A really
Yeah.
big one.
So, I understand their perspective, but it doesn't make it right. If
Right.
you were entitled to put up a fence, which I assume you did and got the proper permits, etc.,
Correct.
then you've done everything you're supposed to do. Anybody who took down that fence, number one, has trespassed on your property. Number two, they vandalized your property. Number three, to the extent they took the pieces of the fence, even though they may have destroyed them, technically that's called conversion. It's a civil tort. So I can probably, as a civil lawyer, come up with 5 or 6 or 7 causes of action, to go after a neighbor for something like that. If you have property on the water, I suspect your neighbors have sufficient money that if they were to be sued, you'd be able to recover the value of a fence, etc.
Well, okay. What happens when I go down there?
Right.
They've called the police 3 times, saying that I don't even know what they're saying.
Right.
And I'd leave and find out that the police were down there, and they called the police. So it's basically they're harassing me, so I don't go there.
Well, and that's difficult too. It's harder to find a cause of action there because lots of people have bad neighbors.
Yeah.
And neighbors can cross the line, and there could be civil or criminal, causes of action. But neighbors who are just nasty, don't like you, say mean things about you, not really much you can do. Now, certainly you can when they come onto your property and they tear down your fence.
Yeah.
Neighbors that are calling the police, I assume about the fence, am I right?
Well, when I first put the fence up, I had the permit posted.
Right.
And all that. I put the first post in, and then I left. I put the corner post in,
Okay.
and I left. Well, they called and said I was trespassing on their property.
Okay.
So now we're down to where the line is and all that. So
Did the police do anything, or they just walk away after they got the report?
I guess they just walked away.
Yeah,
Yeah,
because
'cause
I
what
think
can
they
they-
realize that.
What can they do?
Yeah.
Yeah, what could they do?
Now, I would here's the thought: make sure that the fence is inside the property line.
Well, certainly.
Don't
but
go on their property.
There, in terms of the harassment, which I think is one of your questions, there is really no civil cause of action for harassment.
Okay.
If they were to threaten you, you would be able to get a restraining order. But harassment, I've dealt with many neighbors who have called me about other neighbors, and sometimes it's extreme enough that there's a legitimate cause of action if they wanted to pursue it. Most of the time, there isn't.
Yeah.
But I would say in terms of the fence, and I don't know what the value was, I think you might want to have a letter sent to those neighbors if you're sure you know who they are, either by yourself or by an attorney, telling them to cease and desist, letting them know the cost to repair or replace the fence, demanding that be paid within a very short period of time, and telling them that if it's not done, you're either going to contact an attorney, or if an attorney is writing that letter, the attorney's going to let them know that they may be sued for X, Y, and Z. Sometimes the way to, I'll be blunt, shut up neighbors that are causing you problem is for them to get a letter from a lawyer.
Oh, I hear you.
Because
Yeah.
sometimes then they don't want to have to go hire their own lawyer, so it's easier just to grumble and leave you alone.
Mm-hmm.
Yeah.
So that's one
Well-
option.
Okay.
But you do have causes of action for them coming onto your property and taking down the fence, no doubt about it.
Okay. I have one other issue.
Sure.
I went to a county tax auction. I bought a piece of property for $25.
Lucky you.
Well, not really. The taxes are $1.50 a year.
Lucky you.
So I called the town and I said, "Now what can I do with it?" It was an industrial lot.
Okay.
So the setbacks are such that you can't do anything. So I called the county and I said, "What should I do? It's a worthless piece of property." So the woman said, "Well, just don't pay the taxes. Come October, it'll go back into the auction,
And someone else will buy it.
and someone else will buy it."
Right.
So that was probably 15 years ago. So every year I get a notice saying it's going back into auction. Every year I watch, it doesn't go back into auction. Now I
During
get a
this
bill,
time, are they accruing penalties against you or anything?
$1,900. I just got a bill.
Yeah, see, that's the problem.
Yeah. So if I call and I said, you've been telling me not to pay the taxes and that it was going to go back into the auction, and the woman says, what, you believe everything everybody tells you?
Right, yeah.
Wow.
So I'm wondering,
Well,
I want to get out of the lien against my other properties because of this,
you probably, the best thing to do to get out of that lien is, if it's a couple grand, is to pay it or to make an offer to negotiate it. But in terms of the property itself being worthless, I'm not so sure that's even true. I don't know anything about it, but the property exists and it's zoned. So there has to be a purpose for the property. And if the zoning makes it impossible for you to utilize the property at all, then I would be looking to appeal the zoning designation and to be seeking a different zoning designation that is consistent with zoning in that area. If there's like a lot of areas are industrial complexes or what have you.
But you might be able to put a billboard on it and rent that,
Who
or a
knows?
sign or something.
I don't know. But, it's like if it's an industrial complex, they're not going to make it a residential lot. But if it's industrial, Q1 and maybe Q3 lets you do something that would be productive for you, I would really be looking at whether or not you can change the zoning on that property so it goes from a worthless piece of property to you to a productive piece of property for you. And even if you don't then want to use the property, if you get the zoning changed, you might be able to sell it at a much more substantial price than the tax lien that is on it right now.
Well, the dimensions of the property are 25 by 25, cut corner to corner, half of that.
And how is it zoned?
Well, it's zoned industrial, but I'm not sure, what type of industrial. But it's right against the road, so the setbacks don't let you do anything with it.
Has it ever been utilized before, or is there anything on it, or is it vacant land?
Just a piece of dirt,
Piece of dirt.
I didn't even look at it when I bought it.
Who sold it to you?
The county. So somebody in the town didn't pay the taxes, so it went up for county auction.
Okay, I understand.
Yeah.
And before you bought the property, I have to ask, did you do your due diligence and determine, what the zoning was, what the restrictions may be?
No, I didn't. No,
Okay.
I just walked in. I saw it was industrial, and I put my hand up.
But you're saying it abuts a road?
Yeah, right against the road.
Well, to me, I would think that's a valuable piece of property, even though it's a small piece of property. And I really would look into, and again, this is where, a zoning attorney, and there are plenty of them.
Okay.
People who know the ins and outs. You come to me, for example, on sexual harassment. I'd like to believe I know most of Title VII like the back of my hand. Zoning attorney is going to know all the requirements and appeal methods and all, like the back of their hand. It's what they do. I would like to believe, I would think that a property, even if it's small, particularly one that has, roadside coverage, there must be some way to use it, even if it requires a zoning change. And if that is the case, either you could develop the property if you so desire, or it becomes more valuable to sell. So I would really recommend you contact a zoning attorney.
Okay. Well, I appreciate it.
You're very welcome. Good luck.
Okay, thank you.
You're welcome.
Bye.
Okay, so we were talking about don't just not pay the rent. Because then what's going to...
right. My brilliant suggestion was
Yeah,
deduct it from the rent and give them a receipt. Don't do that, folks.
No, don't listen to the person behind the screen, They're not going to get you back home. They may get you back home and without a home. No, you'll probably get a notice of non-payment of rent, and then an eviction notice. And when you go to court, one of your defenses will not be that they didn't do something and I withheld rent because, You can't do
It
it.
doesn't work. Okay.
But there is a way to do it the right way. Okay? If it is not something that makes the entire property uninhabitable. Okay? So, for example, could heat make the entire property uninhabitable, at least for a period of time? Sure, it can. And in that case, if you send a proper notice, you'd be entitled to vacate. Maybe not terminate the entire lease, but vacate for the period of time that it's uninhabitable, and the rent would have to be abated. If whatever is wrong makes property partially uninhabitable, you may also have the right to vacate for a period of time and have the rent abated. And if you and the landlord can't agree on the abatement, the percentage of rent monies to take off, hey, then a court will resolve that, either on a landlord's lawsuit or on a tenant's lawsuit.
You say vacate. Could you just go like to a hotel?
Sure,
Okay.
absolutely. Vacating the premises.
I mean, because
you can't live
moving's
there.
hard. I mean,
no, I don't mean-
if I'm moving, I'm
yeah.
not coming back.
Right, exactly. And I understand that.
Yeah.
I agree. But now what happens if, let's say, well, let's take the heat situation. The proper thing to do is to send a statutory notice to the landlord indicating the problem, indicating it violates either the terms of a specific statute or the lease, demanding that it be remedied immediately, depending upon what it is. Some things have to be remedied immediately, and some things they have up to 7 days to repair.
Here in Florida, by then it'll be warm again.
Right. So maybe we're not talking about heat itself.
No, but it's a great
You
example.
know, and if there are things that a landlord really can't repair in 7 days for reasons beyond the landlord's control, like a hurricane, then they get additional time. Now, that doesn't mean you still may not be able to terminate the lease, but you can't hold up to 7 days. But the general point I'm trying to make is, if there is a real problem, not a little problem, light bulb needs to be changed. And the lease says it's the landlord's responsibility. Okay, it's not going to, but let's just say. Don't just withhold the rent. Send the statutory notice. They're all over Google. The clerk of court can give you one. Ask a lawyer. Okay? Send a statutory notice that may spur the landlord to actually do what's supposed to be done, even if the landlord might not otherwise have been inclined. If it doesn't, part of that statutory notice says, if after 7 days this is not remedied, we will begin withholding rent. Now you've protected yourself. Okay? So let's say the 7 days has expired and it's the 24th of the month. Your rent is due on the 1st. You withhold the rent. Now, don't go blow it at the Indian casino, because if the landlord sues you for eviction, you have an obligation to deposit that rent in the registry of the court, so at the end the court can determine who gets what. So you still have to have that money. Now, when people call me and we're dealing with this type of a situation, my recommendation is, if you've done the proper notice and now you're entitled to withhold rent, which gets the landlord's attention real quick, I would say deposit that rent money in a separate account. Go open up a checking account, a savings account, whatever, because it also helps show the court that you withheld the rent, but you didn't spend it, you segregated, you had the money. It's not like you didn't pay it because you didn't have the money. And then if you resolve the matter, fine, you negotiate with the landlord. Maybe if your rent's $1,000, you and the landlord agree, okay, he'll take $500, and if everybody's happy, you never see a courtroom. But if you can't agree, or if the landlord is nasty and files a notice of eviction, and then he files an eviction action, and now you have to answer an eviction complaint. Well, when you answer, one of your defenses is the failure of the landlord to comply with its obligations to maintain the premises. And you indicate that you withheld rent pursuant to statute and proper notice. And you ask the court for permission, because you have to have permission, to deposit the rent monies with the clerk of the court. And then what will happen is the court will enter an order that until the matter is resolved, and landlord-tenant matters get resolved very quickly, but until the matter is resolved, if another month's rent comes due, you must deposit it with the clerk of the court. You keep depositing with the clerk of the court until the matter is resolved, and either you have come to a settlement with the landlord and made an agreement, or the court comes to a resolution and says, you get this much and you get this much, and then tells the clerk this is how you disperse it. That is the way you withhold rent, folks. You don't do it on your own. It's called self-help, and don't do it. There are certain types of self-help the landlord can't do, and there are certain types of self-help a tenant can't do. Don't just withhold your rent under any circumstances. You will be sued for non-payment of rent, and there will be an eviction action if the landlord wants to. If the landlord wants to get you out, you've just given him the keys to the kingdom. So you need to do it right.
But while you're depositing your rent money with the clerk, you're still not getting your apartment fixed.
You're right, and that
yet.
may lead to you getting all your money back. It may lead to you getting half of your money back. It may lead to a determination that you have legitimately now terminated your lease and have no further obligations under it. Now, why is that important? There are a couple ways you can terminate your lease. Clearly, to be sure that you've done it in a way that is going to protect you, you need a judicial declaration that the lease is terminated. I mean, you can just say it's terminated. I can write a letter saying it's terminated. But if the other person wants to sue you, it's going to take the court to say it's terminated. The statute says that if the landlord fails to comply with the 7-day notice and the issue is material, what does that mean? It means important. It means substantial. It means it's not a light bulb, okay? If it's a material failure of the landlord to maintain the premises or to make a repair, and the landlord has now not complied with the 7-day notice, and there's no excuse of the landlord that it's due to circumstances beyond the landlord's control, and it's legitimate, hurricane, okay, flooding. Now, you have the legal right to declare the lease terminated. You have the legal right to withhold rent and stay there, or you have the legal right to declare the lease terminated and leave. But as a lawyer, I'm sort of trained to be conservative, even though generally I'm not a conservative. I'm trained to be conservative in the law. I'm trained to look at potential disasters. Not everything works out like at Disney World, even though there you have long lines and it doesn't all work out there either. But if you declare the lease terminated and move out, what happens if the landlord says, well, I don't think it's terminated? And if you're wrong and you've moved out and the court says, well, either you move back in and continue paying rent, or the landlord is entitled to seek all the rent that will come due for the whole term of the lease, the rest of the year, if it's a 2-year lease, whatever, although the landlord has a duty to mitigate damages and find a new tenant, etc., whole nother topic. Now you have a problem for the rent that would be due for whatever months are left on your lease. So it's not the thing I tend to advise unless I've done this like half a dozen times in the last 3 years. Unless in that situation you really want to leave because the landlord hasn't done what they're supposed to do, you come to me or another attorney, and what really should be done is you have your attorney write a letter to the landlord going through all this and offering to negotiate an early termination of the lease so that it's all done nice and politely and agreeably without having to go to court. But without an early termination of the lease, you run some risk. And once we take this next call, we'll come back, and my producer will remind me, we will come back to how do you also protect yourself if you're trying to terminate the lease early from all the other months that are left on the lease and possibly owing rent. So there's the cliffhanger, right, Cliff? Yep. All right, we have Warren on line 2. How can I help you, Warren?
Yes, good morning. Thanks
morning.
for taking my...
Not a problem.
I recently purchased a boat from basically a neighbor.
Okay.
And because I gave him a down payment, and I've been giving him $250 a month on it ever since I purchased it.
Okay.
This month, I gave him my $250 payment, and the balance was only $300. But now he still insists that after I gave him the $250, that I still owe him $250.
Okay.
And I showed him the receipts and proved to him that I only owe him $50. But he still insists that I owe him $250. Now, I know it's only a $200 matter,
I hear you.
and I may have to take him to court in order to settle this. Over $200, is that something I'll have to do on my own, or do I need a lawyer?
Oh, no. That's a small claims court issue. Most people are fully capable of handling small claims court, and at worst or at most, you either call a lawyer for a few minutes of advice on the phone, or you may consult with a lawyer as to, how do you prove your case and what do you make sure you need to do so that you do prove your case and you win. Do you have a written contract?
No, just his receipts.
All right. Well,
they're all his handwritten receipts, and I have the original copies, not the carbon copy.
Okay. Well, at least then you have what's called course of performance. But now the big question, if there's going to be a lawsuit, even over $200, even in small claims court, here's the big question. You say that the purchase price, let's say, was $20,000 and I've paid $19,950. And he says not that the purchase price was $20,000 and you've paid $19,700. He says the purchase price was $20,250 and you owe him $300. Is there anything that shows what the purchase price was?
Only basically on the first receipt.
What does it say?
The first shows that I gave him $500 down, and the $500 down, there was no receipt because that was on January the 1st. But then on February the 1st, I gave him $250, and when he gave me that receipt in February, on that receipt, he wrote on the very beginning of it, there was $500 down, and then there was $250 payment on February the 1st, and then that showed the remaining balance.
Excellent.
Of $1,050.
Well, that gets you exactly where you need to go to show the purchase price.
Yeah, I mean the purchase price wasn't actually listed as $1,800.
Right, but it shows what's
balance
left.
due tells you,
Yeah, people can do basic math, and if it shows what's due, and you can show what you've paid, I would think that's basic math.
Right.
Have you actually shown to him? I mean, is he just being, I'll be polite, a jerk, or is it a honest misunderstanding, and he needs to be shown that you've actually paid everything other than $50?
Well, unfortunately, I think he's just being a jerk, and he's a preacher, and for whatever reason, he just wants like $200 extra.
Well, I will tell you this. Here's how small claims court works in a nutshell. I know we talked about this on another show. Over a $200 issue, it's not going to be a very expensive filing fee. I'm not sure what it is, but maybe it's $49. Okay.
Right.
And they'll serve him with the summons and complaint by certified mail, so that's no big deal. Okay. And if you win, the judgment will include the filing fee costs, and you'd be able to get that back or have that taken off of what you owe him. Let's say the $50, and it's your boat. Okay.
Right.
The problem becomes it requires 2 court appearances. Right. The first time you go, they send you to an attorney to mediate and try to get you to come to an agreement. So it's $200 at dispute. I know what the attorney's going to try to do. He's going to turn to both of you and say, you, Mr. Seller, just take $100 and be done with this. And you, Mr. Buyer, I know you disagree, but pay $100. It's an extra $50. You don't want to have to come back here. And the attorney who's telling you that won't really be wrong. It's good advice. But let's say one of you says no. Then you're going to have to come back on another day that the court sends a notice, and that's the day for trial. Okay? Now, a small claims court trial, it could be 15 minutes. but you're coming back again. Now, okay, he's coming back too. If you want to go through that, and if you doesn't bother you, it is a reasonable course of action for you to get your boat. If the idea of doing that means that you'd rather pay something extra, even if it's a $200 or whether it's $100, and you negotiate with him, then that may be the better course of action. Which one is better for you really depends upon you. I think legally you're in the right. The question here is, how much will the time expense, the aggravation expense, what is it you're willing to endure to prove your point? And you have every right to go prove your point. I'm not putting that aside. I'm just saying, if you are a person that says, I don't want to do this, it's just not worth the effort, then the reasonable alternative is either to try and negotiate with him, send him a formal letter threatening to sue him.
How about photocopy all your receipts and just give them to him? Let him do the math.
You know,
I've already done that.
Oh.
I took the original receipts and I made photocopies.
Okay.
I made extra copies.
Well, I'll tell you. I'm sorry to interrupt. Go ahead.
Yeah, and I give them to him, and he's saying, no, this ain't right. But
well, the last thing I guess I could suggest, sometimes I do things like this, is you get the small claims packet. It has a statement of claim document, and you basically write one paragraph that explains this. Send it to him. Don't officially file it or serve it. Send it to him with all the receipts and everything you've already given him, you know.
Yes.
And say, hey, look, I'm ready to go, buddy. It's go time, or let's solve this now, or I filled out the paperwork, I'm going to file it, and we're going to be in court. Sometimes seeing a document actually prepared makes somebody have second thoughts.
Because really, what is he holding, like a title?
Right.
Okay.
Right.
Yeah,
it's personal
he's got a
property was the
lien.
title.
And that's it. He's got a lien on the
Right.
title. So, I mean, he's pretty smart on that part. He's got a lien on the title, so it's got my name and his name on it. And he's kind of threatening me about not taking the lien off. But if I get him in court and I do win, am I allowed to ask for time off of work and other than that, or am I just allowed to get filing?
Just the court costs. You don't have a written contract. No, you wouldn't be able to get time off and all that kind of stuff.
All right. I guess that's kind of my question.
All right. I wish you the best of luck.
Yeah, all right. Thank you, and thanks for talking with me.
You're welcome. Folks, we have about a minute, so we got to wind up. And guess what? I'm not going to get to that other part of protecting yourself. So there's a cliffhanger for next week. I will sort of mark my notes here and make sure I deal with it. Until then, I'm Stuart Address. My office is in Stuart, Florida, just over the Roosevelt Bridge. The office number is 781-8003. Cheryl will be happy to take your calls and talk to you and then come chat with me. So have a great weekend, and thank you for listening to Ask a Lawyer.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.